Hello, friends and clients of JLW Immigration Law Group. I am Jennifer Walker Gates, board certified immigration attorney, and I am here today to talk about what happens if your application for citizenship is denied. This is a question that's coming up a lot, especially in the context right now. There's a lot of discussion about denaturalization. A lot of lawful permanent residents who are applying for citizenship but don't really know if the risks have changed for them or not. And so we are going to be talking today about what are the steps that follow if a person's citizenship gets denied. So before we get into that topic, I do want to ask everyone to please share, subscribe, and comment. This information is intended to be for everyone, whether you're working as a client with our firm, with another lawyer, or if you're going on your own through any kind of immigration process, be that citizenship or anything else. We want everyone to have accurate and reliable information. That is our goal, so that you can be as successful as possible in your process. Of course, if you have a specific question or concern for yourself, we won't be able to address that in this forum, but we welcome you to contact us directly for an appointment. We would be honored to consult with you confidentially to answer your specific questions. In this forum, we welcome you to ask questions as well. Post your questions, drop them in the comments. Whether you're watching on Facebook or YouTube, we will respond to those at the end of the session, and hopefully you can get the information that you need here for free, but from a reliable source. So with that, let's talk about what happens if your citizenship gets denied. So before we even get to the denial part, let's talk about what makes someone eligible to apply for citizenship. If someone is applying for citizenship in the United States, you're usually going through what's called the naturalization process. And in order to qualify for naturalization, you have to be first a lawful permanent resident. That means you have to have a green card before you can apply for citizenship, okay? And having a green card is a really strong immigration status. That's a really potent immigration status. It is not 100% protection against deportation. If someone who has a green card commits a very serious crime, they can be deported. And if they commit more than one, even semi-serious crime, they can be deported. However, short of something like that, serious criminal stuff, lawful permanent residents don't get deported, okay? And that's true even if your citizenship gets denied. Just because your citizenship gets denied doesn't mean you're going to be deported. Now, sometimes in the citizenship process, it comes to light that someone defrauded USCIS or Department of Homeland Security or the US government in the process of getting their green card. If that happens, USCIS, DHS will try to remove that person. They will put that person in deportation proceedings. That does not necessarily mean they will be deported, okay? Even if you committed some fraud in the process of getting your green card or misrepresentation, you can often, after a certain number of years, you can go into the immigration court and you can seek a waiver of that fraud or misrepresentation that occurred. You can fight your deportation in the court and hold on to your permanent resident status, okay? That is entirely possible in many, many cases. So just because your citizenship gets denied, that's point number one. That doesn't mean you're going to get deported, okay? It's really, really important to keep that in mind. Most people whose applications for citizenship are not approved do not get placed in deportation proceedings. The reason that most in my practice, in my years of practice, the number one reason I've seen people get denied their application for citizenship is because they messed something up on their application. They gave the wrong answer. Either like their question was something like, have you ever been arrested? And they answered no. And then in their interview, they repeat that same error. No, I have never been arrested. When in fact, they were arrested, but a lawyer told them it was expunged or something like that, so they never had to mention it again. A lot of people make that mistake. If that happens in your citizenship application, you're likely to be denied. Your citizenship application will likely be denied because you have misrepresented the truth in the application itself and in the interview. One of the requirements for becoming a US citizen is good moral character. So if you go into the interview and you say, I have never been arrested, when in fact you have been arrested, USCIS often will deny that application for lack of good moral character. What that means is you have to start a 5-year period over again. And then the next time you apply for citizenship, you have to make sure that you disclose, not only have I been arrested, but I have also in the past committed misrepresentation. You have to admit to both of those things in your next application in order to not get denied again. So if there's anything in your immigration history that says, for example, I had a client who had a U visa. Now, U visa applicants are able to get waivers of false claims to US citizenship. That is something that almost does not exist in any other part of the law. But people who qualify for a U visa can get a waiver of that ground of inadmissibility. In this particular case, this person, as a teenager, had been brought into the US and presented a birth certificate of a US citizen. Then later, many years later, she got a U visa. Then many years later, she applied for residency. Then many years later, she applied for her citizenship. And she did not think that that thing mattered anymore. That incident that happened when she was a teenager, when she was coming in and made that false claim to US citizenship. She applied for citizenship on her own. And she said, no, I have never misrepresented anything. No, I have never claimed to be a US citizen. She put that on her application. Then when she went to her interview, she said the same thing. The officer asked her the questions. Have you ever lied or misrepresented to any US government official to get an immigration benefit? Claiming to be a US citizen so you can come into the US is misrepresenting something in order to get an immigration benefit. But she said no. Therefore, her application was denied and she was required to wait 5 years to reapply. So it's that kind of error on an N-400 form and in the N-400 interview that most often results in denial of an application for naturalization. However, most of the time, this will not result in removal proceedings for that lawful permanent resident. What the Department of Homeland Security would have to prove in order to actually deport that person is very strict and difficult. In order for a judge to take away someone's lawful permanent resident status over something like that, there has to be no waiver available. It has to be a very serious thing, and there has to be very strong proof. That's not the case in most of these cases. So be honest in your application. Make sure you disclose everything. It's better to over-disclose on things like complications in your immigration history or any kind of encounter with the police than to assume that it doesn't matter or it doesn't count and it's not going to be known to them. It is really important to disclose as much as you can ahead of time, just to make sure that you're not going to be caught in this trap of and accused of misrepresenting something. Now, let's say your application for naturalization gets denied and there isn't a valid basis for the denial. Let's say they deny your application for good moral character because they think that you, for example, cheated on your spouse or something like that. This is something that can happen. Okay, if USCIS determines that you started a relationship with a person while you were still married and it tended to destroy the original marriage, that new relationship. Was it, if it was an instance of infidelity and it happened during the 3 or 5 years that you were supposed to have been show good moral character for naturalization, sometimes they will deny the case. Okay. This is just an example. I've seen cases denied for other reasons that I also felt were inappropriate. One recent one that I've seen is someone who was outside the US during the pandemic and got stuck. They wanted to come back, but they could not. And that intention to return was very, very important. And they were able to demonstrate it. Still, USCIS denied their application for having broken continuous physical presence in the US. This is a legal argument that we're having with them. The way that we're doing it is Form 336. Okay, so if your application is denied, you have the right to file for a review of that denial on what's called Form 336. That is a notice of, I can't even remember what the USCIS terminology is for Form 336. And 336 is request for a hearing on a decision in a naturalization proceeding. Okay, so if your application if you actually receive a negative decision on your application, you can file in 336 and get another interview, and you get another chance to present your case. If it's then denied again, you have the right to take that case into the federal district court where you live and ask that a judge review the denial. Now, depending on where you live and what kind of history and other types of cases that court has seen, and kind of the disposition of that court towards immigration in general, might be a really good opportunity to get a fair chance to pursue your naturalization. Or it might make more strategic sense to go at it a different way, depending on the circumstances of the case. Many times a denial of a citizenship application doesn't mean you're denied forever, but rather that you need to wait the 5 years, or you need to wait a couple of more years to reestablish your physical presence to meet that requirement for naturalization. So sometimes the denial means you need to file an appeal, and sometimes the denial means you just need to wait a little bit longer to be able to prove that you fully comply with all the requirements for naturalization. There are a number of options and strategies available to people whose application for citizenship gets denied. Most of them do not involve removal proceedings. The one time when you, again, might be facing removal proceedings if your application for citizenship is denied is if USCIS determines that you definitely committed fraud when you became a permanent resident. If they discover that there was definitely either marriage fraud, the marriage was completely not legitimate, you paid someone to marry you so you could get your green card. If that is discovered, they might put you in removal proceedings for that. If there is criminal activity that somehow wasn't discovered or disclosed, they would likely put someone in proceedings for that. In the majority of cases, however, a denial of a naturalization application isn't going to result in removal proceedings. So I hope that that's helpful. I hope that that's clarifying for a lot of people, and I hope that it puts a lot of people at ease and encourages people to apply for citizenship. It is still a good time to apply for citizenship in spite of a lot of scary enforcement that we're seeing right now. It is still, the requirements for citizenship have not changed. The test for citizenship remains the same as it has for several years. And so if you have been a lawful permanent resident for at least 5 years, or just 3 years, if you're married to a US citizen who petitioned for you to get your residency, so 3 or 5 years with your residency, you've been a person of good moral character during that time, generally meaning no arrests, no convictions. Traffic tickets are okay. there's no fraud or problem in your immigration history that hasn't already been disclosed and dealt with in your residency process. You have spent at least half of your time inside the United States since you became a permanent resident. You filed all your taxes. Your taxes are all caught up, and the IRS, if you do owe money, has you on a payment plan and you're complying with that payment plan. If you're supporting your dependents and being a good parent and generally being a good person, then you should apply for US citizenship now. Definitely apply as soon as you can. And you have to speak English. So if you're able to understand me right now, the odds are very high that your English is just fine for citizenship purposes. Your English does not have to be perfect. Having an accent is completely fine. Many of the USCIS adjudicators are themselves naturalized citizens who have an accent when they speak English. That is perfectly fine as long as we can understand each other. We can carry on a conversation about your application. You're able to pass the civics and government test. That is all that you need to prove to become a US citizen through the naturalization process. Definitely a good time to do it as soon as you can, in my opinion. We are happy at JLW Immigration Law Group to assess eligibility for anyone who is interested in applying for US citizenship, and give you our very, very honest opinion about the likelihood of your success, about whether there's anything else that needs to change or shift in your profile in order to make you eligible. We're happy to consult with people who are going through the process on their own, look at your application with you, answer questions. We want to do whatever we can to help people get across that finish line. The question about prolonged travel outside the United States, any future issues that could come up, that gets answered, generally speaking, by the naturalization process. And as long as there's no fraud in that process, your naturalization will remain secure for the foreseeable future as well. So again, please share this video, subscribe to our channel, leave us a comment. We're happy to answer questions, and I'm going to be getting to questions right now from our viewers. But if you would take a moment, share, subscribe, like our videos, and contact us directly if you need an appointment. Our information is scrolling along the bottom of the screen. You can call us or go to our website and schedule an appointment with me or any of the attorneys in our firm. We will be honored to help you determine whether you are eligible for citizenship or anything else. Okay, I see some questions. Hi, Sandra. Yes, please, puedes agendar una cita tras el sitio web o llamando a la oficina. Entonces, por favor, haga eso para una cita privada confidencial. Y en esa cita estamos dispuestos a analizar su caso, contestar sus preguntas, hacer un plan de emergencias. Eso es algo muy común que estamos haciendo hoy, en día y en estos días, es preparando para emergencias y avisando a personas de cómo protegerse en caso de emergencia. Polo, mucho gusto. Hola, abogada, ¿cómo está? Estoy bien, a pesar de un poquito cansada, pero gracias a Dios bien. Y es un placer estar aquí con ustedes. Let's see. Do we have other questions? Let's see. ¿Cuánto es el precio para el trabajo de una ciudadanía? So, el precio depende. Si está preguntando sobre los costos de nosotros, eso depende y puede variar mucho dependiendo del caso. Entonces, sin una entrevista detallada, no es posible anticipar con exactitud. Los costos para inmigración varían también dependiendo si está archivando su aplicación en línea o si la está archivando por correo postal. Ahora las aplicaciones en línea, ellos cobran menos que las aplicaciones por correo postal. Las aplicaciones en línea cuestan un poquito más trabajo para el abogado al principio del proceso, pero vale la pena, en mi opinión. He usado ese sistema para archivar aplicaciones ya docenas de veces y realmente, a pesar de las inconveniencias al principio, va muy rápido, pues, nos da una respuesta, el recibo de inmediato, instantáneamente, y por eso me gusta mucho que el cliente también tenga acceso al estatus actual de su caso en su cuenta en línea. Entonces, tratamos de hacer eso. Cuesta $50 menos. El costo de migración ahorita es para una aplicación postal $760 y para su aplicación en línea 710. Ok. Kim, mucho gusto verla. Dice, buenos días. Le ayudé a una amiga a solicitar su permiso de trabajo a los 163 días basado en el reloj del asilo. USCIS lo denegó diciendo que tenía que tener más de 150 días en el reloj. No entiendo. Ok. Bueno, esto no es incomún tampoco. El reloj del asilo causa mucha confusión y muchas complicaciones. Si la persona tiene un documento, captura de pantalla o algo así demostrando que su reloj ya tiene más días que son necesarios y ya tenían esos días cuando metió su aplicación, se puede pelear o simplemente puede aplicar de nuevo para la aplicación. Realmente depende, porque ahora como hay más costos y también los permisos se van a otorgar para un año a la vez y no 5, tal vez vale la pena pelear la aplicación anterior. Lo que nosotros no sabemos todavía es si aplicaciones archivadas durante esas últimas semanas, después del 4 de julio, cuando el presidente firmó la nueva ley sobre los permisos parcelados, no sabemos si los permisos archivados durante ese tiempo se van a otorgar para 5 años o solo un año a la vez. De todas maneras, desafortunadamente, esa persona va a tener que pelear, seguir luchando para su permiso de trabajo. No hay manera fácil de simplemente corregir el problema. En mi experiencia, a veces vale la pena simplemente archivar una nueva aplicación. Es importantísimo tener a alguien revisando la aplicación que sabe los requisitos. Entonces, si está ayudando a una amiga o un amigo con su aplicación, es muy buena intención, pero puede tener consecuencias también enormes. Entonces, hay que consultar con un abogado o alguien de confianza que sepa la ley de inmigración para poder decirle, ok, este es correcto, este no es correcto, este va a causar que la aplicación sea rechazada, denegada, etcétera. No sé si todo fue correcto en la aplicación o no, sin verla, pero eso sería mi recomendación, es definitivamente usar a alguien que tenga mucha experiencia preparando aún las aplicaciones para permisos de trabajo. Parecen fáciles, pero realmente son complicados. Ojalá que tenga suerte, que tenga éxito con su permiso de trabajo. Ojalá que todos estén seguros. Si califica para la ciudadanía, por favor, hazlo. Si necesita una cita, por favor, comunique con nosotros. Voy a publicar nuestra información. So, estamos en Austin, Texas, y el número de teléfono de la oficina es 512-633-1785, pero podemos trabajar con personas desde todos los Estados Unidos. Estamos, de hecho, de todo el mundo tenemos clientes. Y con esta tecnología, ahora es posible reunirnos bien, así virtualmente, y ayudar a personas en muchos otros países, en muchos otros estados. So, no duden en comunicarse con nosotros, sí podemos ayudar, y con gusto les podemos revisar y analizar su elegibilidad. Le refirió a algunas personas. Ándale. Muchas gracias, Kim. Estoy muy agradecida por sus referencias y recomendaciones. Yo tengo muchos colegas excelentes, y yo sé que cuando tenemos nosotros un cliente, no, yo sé exactamente cómo los cuidamos y cómo cuidamos a su caso. Entonces, para mí, la idea es que todos tengan éxito si están trabajando, sean clientes míos o de un colega de confianza. También reconozco que hay algunos, aún abogados con licencias, que realmente no son de confianza. Entonces, hay que tomar cuidado. Hay que realmente analizar la información publicada, las revistas, las experiencias de sus amigos y familiares cuando están tratando de trabajar, determinar con qué abogado trabajar. Free and curated legal information in your inbox every week. Join our newsletter. Okay, the enlace, the link in the banner on the screen, jlw.law/newsletter. That is a way that you can get information from us about things that are going on in the immigration world that impact our clients, our communities, our families, and strategies for how to deal with them, tips for how to deal with them, links to other resources. So please sign up for our newsletter to get regular updates. And with that, I'm going to sign off. It has been great to be here with you. Thank you all for being here. Gracias por venir a los Estados Unidos, contribuir a los Estados Unidos. Estamos súper agradecidos que ustedes han escogido a nuestro país para contribuir su energía, y ojalá que todos siguen seguros y que nos vemos otra vez en la semana que viene. We will see you next week. Please stay safe until then. Wednesday at noon. We'll see you then. Bye-bye.